Hi, I'm Mike Collins from Collins Property Managers in Jacksonville, Florida. Today, I'm here to talk to you about the legal requirements of a security deposit for your rental home. My message is to be extremely careful, and there is a specific statute, it's Statute 83 of the Florida Statutes, that contain all the rules about security deposits and leasing. First of all, one thing that you need to keep aware of is that the tenant's security deposit does not belong to you as the landlord. It actually belongs to the tenant, and you are holding it as safekeeping to cover any potential damages that would occur at the end of the lease when the tenant moves out. You're also required to keep all the funds in a Florida bank, and it has to be a Florida branch of a Florida bank. So for example, if you have a Bank America account and you live in Virginia, you would not be able to deposit that security deposit in a local Virginia branch. The next thing that you need to be aware of is that you cannot take any of these funds out during the term of the lease, even if you know that there's damages. You have to leave every penny of that security deposit in that account until the tenant has physically moved out of the home. Once the tenant has moved out of the home, and you can verify that, you must then get to the home or have someone get to the home on your behalf and identify what all the problems are and what you're going to be claiming. The notice of claim against security deposit is a Florida document that you're required to send certified mail to the tenant, and that document must have in detail what the damages are, and it must be sent to the tenant within 30 days of the date that they moved out. If you do not send that letter to the tenant within the 30 days, you are not legally permitted to charge the tenant anything. On the letter, and once you've resolved and fixed all the things that need to be fixed in your home, you then have to have basically a receipt for each of the things that you repair, and those must be for actually work done. They cannot be estimates for work to be done. And then finally, you are not allowed to charge for your personal labor or the labor of your family members. So for example, if you paint the house, you can only deduct for the supplies of the paint. If you hire a professional to do it, you can deduct the entire amount from the security deposit. In closing, if you don't follow these rules, and the rules can be somewhat complicated, you will be in a position where you would have to forfeit and give the tenant their deposit back and possibly pay damages and their court fees, and if you have an attorney, your court fees. So it can become really, really expensive if you don't know the law and don't follow it. Courts tend to be very favorable towards the tenants in Florida, so you need to be aware of that. My suggestion to you would be to hire a property manager to manage your property, and we of course are here to answer any questions that you might have about that. Thank you very much. Again, I'm Mike Collins from Collins Property Managers in Jacksonville, Florida.